Welcome to Raising the Bar podcast,
sponsored by the Ashmore Law Firm.
We're your hosts and siblings,
Gary Ashmore
and Lori Ashmore Peters.
Subscribe so you don't miss a single episode.
All right, welcome to our Raising the Bar podcast, hosted by the Ashmore Law Firm. You have me, Lori.
Do it again.
Ashmore.
Sponsored by.
God
You and I are
bless
hosting it. How many times have we done this?
Too many.
Okay, go ahead. Do it again.
Welcome to our Raising the Bar content.
This is why we have several takes. And you know what? We do outtakes too sometimes because this is ridiculous, right?
Have you tried to do one live? That'd be really fun.
We did.
We did a live one.
We did a live one and it went great.
With a Vietnam veteran.
It was fantastic.
L.A. Olson. He's written a book. You'll need to check out that podcast.
Yeah.
It's a really good one.
So you really did that one live, no editing?
Yes, no, out there, correct. There were five, six, seven of us, live audience.
Yeah.
Oh, wow.
I mean, it was about 45 minutes.
Yeah.
Right, it was.
The whole thing was like an hour.
Oh, was it?
In each section.
Yeah, it was phenomenal. It was fantastic.
It was so great you've never wanted to do it again.
No.
Oh, no, I would love to do it again.
You know who we had on it was Glenn Morshower. He's an actor, and he's part of this. He's part of this book and this documentary that they're putting together. And he plays typically military officers in all these movies, from Transformers to Black Hawk Down to
Star Trek.
Oh, wow.
He does
Call of Duty. He's the voice
does the
in Call of
voiceover on Call of Duty.
Yeah.
Amazing guy. He went to Hillcrest High School. He's from here. And it was so interesting because he was part of the panel that day. It was fun. In fact, we have a podcast just with him. Has that one dropped yet?
Yes.
It dropped as well.
And Carrie.
Him and Carrie Graves.
Just with him.
Just with him.
He's one of those that as soon as you see him, you're going to be like, I know who he is. I never
see
knew
you all
what
the time.
his name was.
But you never know who he
You
is.
go from prolific movie actor to the appellate lawyer. I mean, you're going down really fast. I mean, this might be the end of the podcast, okay? At the rate you're going down, ooh.
That's hilarious. That's
Oh,
great.
my God. All right, so we'll try it again.
All right.
Welcome to Raising the Bar podcast, sponsored by the Ashmore Law Firm with your hosts, Lori Ashmore Peters.
And Gary Ashmore, siblings.
Yes, not husband and wife. And we are so happy to have our guest with us today, Chad Ruback.
So hold on. I think we need to say nationally renowned
Yes.
and critically acclaimed appellate attorney Chad Ruback.
There we go. I like that.
Of
I like
course,
that.
of course.
Does that suit you okay?
It's a bit of an exaggeration, but I'll take it nonetheless.
See,
Hey.
he says that. He's modest. It's okay.
For our viewers out there, we've seen you on local TV. I've seen you on national TV. You're everywhere.
I'm ubiquitous. I've been accused
Do you know
of
what that
at
word
least.
means?
I have no idea what that word means, but I love it.
But that's Gary's
Okay,
word
wait.
of the day. What does
Yes.
it mean?
Omnipresent. I'm everywhere.
Okay. I'm going to start using that. I like it. Ubiquitous.
So that's going to
And
be
omnipresent.
Gary. That's Gary's word of the day today. Use it 10 times
I'm going
correctly.
to. Okay.
All right, Chad, thank you so much for being on our show today.
Thank you for having me. It's always fun to hang out with you guys.
course.
Absolutely. So appellate law, we always tell people being an attorney is just boring.
Yes.
No argument there.
Depends on the day. Depends
It
on the
does
day.
depend on the day.
I mean, but as an appellate attorney, don't you ever have those? And I know you're going to back me up.
I am.
And that's fine.
But go ahead. Back
But-
up. When she says back up, it means rewind. But,
Rewind.
but go ahead.
But right now,
Go
I
ahead.
mean, my question is always this. As an appellate attorney, I know as an attorney, we always have those oh shit moments, right?
Yes.
I mean, it always happens. And so
Weekly,
Do
daily,
you-
hourly, depending on the day.
That's right.
So I'm just curious to know your oh shit moments. Is it because it's a judge that just like was way off the mark with the ruling? Is it because it was an attorney that it was just like, oh dear God, why did you ask that question the way you did? Or is it with the client when they're answering the questions?
It's actually after I get hired and a client tells me what the case is about, and I begin to do a little study about the case myself, and I see the client had no idea what this case was about. They've told me, this is an issue in the case. That wasn't an issue at all. It's
Right.
7 other big things, but the thing they were talking about turns out is a non-issue. It wasn't even on the record, but these 7 other things make the case much more complex than the client ever would have imagined. And I have to have the call with the client saying, well, I do see some appellate issues here. It's not the one you thought I would see,
Right.
but I'm seeing a bunch of them. And, let's discuss strategy in light of what I've seen about the case rather than what you thought I'd see.
Right.
That's my oh shoot moment.
So when stuff like that happens, though, if you're not brought in till after the case has been tried, then obviously it's harder for you because now you're having to, in some instances, clean up what the lawyer may or may not have done correctly, right? Or what they may or may not have advised the client of. Is that right? Because
That's all very true. What I like to explain to people is on an appeal, you can only complain about what the judge did wrong, not what the lawyer did wrong, not what the witness did wrong. And you can only complain of that, what the judge did wrong, if error has been preserved, meaning if it was an objection properly lodged.
Right.
And if, let's say, the judge did something awful, but the lawyer didn't object or didn't do something else to preserve error, maybe filing a document as to the judge's error, often you can't address it on an appeal.
Right.
So you can't get on a time machine and go back and raise a timely objection or file a similar document, an analogous document to an objection. I definitely have some oh crud moments where I have to explain to the client, well, that thing that you thought was going to be something good to argue on appeal, we're going to need to look for something else because this wasn't preserved.
Right.
The appellate rules are such that error is required to be preserved to protect the judges. Judges are human. Judges make mistakes, just like the rest of us do from time to time. To protect the judges, the rules require, generally, that a lawyer apprise the judge of what he or she has done wrong right after it happened.
Right.
That'd be an objection. That'd be a written filing similar to an objection saying, hey, judge, this is something you messed up. Here's how you can fix it. If that isn't done, if there is no error preservation, if there is no timely objection, if you will, lodged, it really would be sandbagging the judge, be laying behind the log, and months and months after the judge's ruling, faulting the judge for something he or she did wrong without ever having given him or her an opportunity to get it fixed at the time. So when you think about it that way, it really isn't unfair to the party to require error to have been preserved. It's protecting the judge. If the judge is told right away, Judge, what you're doing right now is messing things up, and that's done in an objection or an analogous filing, the judge can then say, oh my gosh, you're right. Let me fix it. Let me course correct. But if you wait till after everything's done, months and months later, and then point out the judge did something wrong, that's really not fair to the judge because the judge might not have known he or she was doing something wrong, might not have had an opportunity to fix it. So often the biggest oh crud moments I have is when I see something that would have been a great point to raise on appeal, where the judge really, really messed something up.
Right.
But the lawyer didn't preserve error, didn't bring it to the judge's attention in a timely fashion to give him or her an opportunity to fix it. And that's generally required by the rules to win on appeal.
That's
Right.
a fantastic I've never heard it explained that way, but man, now I understand appeals.
Yeah, no, it very much so, right?
And I mean,
it was in layman's
personally,
term.
Yeah. Oh,
Right.
it was perfect. And for us as a law firm, we have learned early on because we have known you, I think, forever. It feels like forever.
25 years.
It's
At
been
least,
a long
yeah.
time. That whenever we have a case that's going to trial and we know the parties and we understand both sides, it's like call Chad on the front end.
Yeah.
So that he's involved at the get-go of it to make sure that, attorneys are also human.
Right.
And there's a lot going on when you're in a courtroom and testimony and what's the next question you need to ask to make sure that the attorney does preserve that error.
Absolutely. And a lawyer can only be doing so many things effectively at once. I mean,
Right.
if you're focused on eliciting the perfect testimony from a witness, that requires a lot of focus, a lot of concentration. You can't also be focused on, what the jurors are looking at, or, if someone's giving you an odd look when you're asking a question. Can't be focused on what the judge is doing. Can't be focused on what the legal issues are that might be implicated by specific answers that the witness might be, providing, that sort of thing. For a case that merits it, for a case that's large enough dollars-wise,
Right.
it actually requires several lawyers to get the best possible representation for a client. I mean, if the case is small, you want one darn good lawyer who's pretty darn good at everything. But there's no way one person can be watching the judge, watching the jury, can be looking up, an obscure rule on Westlaw, for example, all at the same time. I mean,
Right.
you can't possibly do all those things. If a case has enough money and controversy, generally you want a trial team to have 3 or 4 different lawyers all on that team, all doing separate things, because one person can't be doing everything simultaneously.
So would you recommend then as part of your practice that and if anyone's listening to this, as far as bringing in an appellate attorney, it's best to bring them in prior to trial so that they're there for your final trial?
Yes, long prior to trial. When someone asks me, ideally, when is the best time to first consult with an appellate lawyer, I tell them it's before they file their initial petition or first file their answer.
Right.
Not necessarily have the appellate lawyer involved in every single thing, but if the case is worth enough,
Correct.
it's worth having an appellate lawyer at least on standby early on in the case, because appellate issues arise long before trial. And if you don't address them at that time to preserve errors we discussed, often it's going to be too late before the trial even starts.
Right. Okay. All right. So those of you looking or considering an appellate attorney, make sure you let them know ahead of time.
Yes.
Before you even file the petition, as Chad had just mentioned. So we've asked you, and I'm going to ask you here in a minute, what areas of law do you like to do as far as appellate work? I know we just had you on a big family law jury trial, and you're helping us with that. You were helping us during the trial and obviously post-trial. So what kind of areas do you prefer or like or don't like?
I don't work on criminal cases, and there's
Okay.
a reason for that. Texas is one of 2 states in the country where there's bifurcated high courts, meaning there's one high court for criminal cases and one high court for civil cases. Oklahoma is the other state. That's your trivia for the day.
Good to know.
The other 48 states, there's one Supreme Court handling all criminal and civil cases. Because Texas is one of the states where there's separate high courts for criminal case and civil cases, I've chosen one, the civil high court, and that's where I focus my education, my reading, my knowledge. There's just too many cases coming out of the 2 separate high courts for me to stay up on everything they're both doing.
Right.
So I only take civil cases. I don't take criminal cases. Within the civil realm, I work almost exclusively in the state courts of Texas rather than federal courts because, again, I can only stay up on the cases coming out of so many courts at once. It's all I can do to know everything the Texas Supreme Court is doing without also worrying about, okay, what is the Fifth Circuit, the federal circuit court for this area up to? I like to know what I'm doing. I don't like to just, go by gut feel.
Right.
So my practice is almost exclusively Texas state civil appeals. Within that, do I have any preferences? Not really. I enjoy doing family law appeals. I enjoy doing probate appeals. I enjoy doing business disputes, torts or injury type cases.
Right.
There's not a single type of civil case in the state of Texas that really makes me shake my head and say I won't do that anymore. I mean, I do oil and gas cases periodically,
Right, okay.
less so than some of the other types, just because most of my practice is referrals from Dallas-Fort Worth area lawyers,
Right.
and there just isn't as much oil and gas work here as there is, say, out in West Texas, for example. But I have worked on a handful of those cases, absolutely. I really enjoy working with fun people, and when I say fun people, that's fun lawyers like yourselves, also fun clients, and you generally have some of those too. You have a lot of characters
Yes.
We
who
do.
come to the Ashmore firm for legal representation.
We
You
do.
don't have a lot of boring clients.
No,
at this
they're
firm.
not. That's right.
So I mean, I like working with people that I like working with. I mean, meeting
Right, of
lawyers
course.
I like working with and clients that I like working with. That to me is a lot more important than the subject matter. I could handle dry subject matter as long as I'm working with fun people, but working with boring people, no matter how interesting the case, I like having fun at work because
course.
it's such a huge percentage of my waking hours.
Yes.
I am a workaholic. I don't really have any hobbies. This is what I do as I work. And because this is pretty much all I do, I, sleep, work, and, periodically try to get a shower in there, brush my teeth.
That's good. Okay.
I wanted to be with people who are fun to be with.
Yeah.
Right.
So
Yeah.
there.
No, I love it. Okay, so have you always loved to read?
I've always loved it. My taste in reading has changed a little bit. I used to be a voracious reader. In fact, when I was in high school, I'd pick up a book, and within a few pages, I would either be really, really into it or just put it down and think this is junk. And if I was really into it, I wouldn't put it down till I was done. So I would stay up all night reading a book. And my parents told me I was antisocial because I spent a lot more time reading than with people. And the reason y'all are laughing is probably because most people would not consider me antisocial today.
At all.
Not at all.
Now, though, interestingly, I don't pleasure read at all. I haven't in
Okay.
years because I spend so much of my day reading. Whether it's
Right.
reading recent cases that have come out, reading transcripts from a case I'm working on, reading filings from a case or analogous cases. I spend so much of my day reading that when I try to pleasure read, I can't do it without a highlighter, without a little sticky tab, without a notepad, because my mindset is, if I'm reading, I need to know all the important content. I need to have notes, so I go back to page such and such because that's an important issue. I can't relax when I'm reading because that's just how my mind works now.
Right.
Very, very different from how high school Chad's mind worked, where I could just completely relax and lose myself in a book. I can't lose myself in it anymore because I need 3 different color highlighters and 7 different stickies for me to read something. So it's not relaxing anymore. So I've always been a big reader. My reading style has changed a bit.
There we go.
And it's not as relaxing as it used to be.
Right.
I'm
Okay.
intense when I'm reading now. And that's not conducive to true pleasure reading.
Right.
So do you have well, I'm going to back up because,
Go ahead.
as an appellate lawyer, that's all we've ever known you to be. Where were you born and raised? Were you
Born in Leawood, Kansas. As they say, I got here as fast as I could.
Okay.
I moved to Texas July 14th, 1991.
Okay.
A few weeks after I graduated from high school. I was offered a full academic scholarship, almost full academic scholarship. I think they made me pay $100 a year to the University of Texas.
Oh, okay.
I was a National Merit Scholar there, and I knew I did not want to stay in Kansas, but I wanted to be within a day's drive of Kansas so I could get home and see my family around the holidays.
Right.
And so I kind of did a little mental map for, what is 12 hours north of Kansas? No, that's cold.
Right. Okay.
What is 12 hours west of Kansas? Yeah, that's still cold. 12 hours east of Kansas, cold. 12 hours south of Kansas, Austin, Texas, thumbs up. I know where I'm going to spend the next few years of my life.
Right. Okay.
And after graduating from UT, I was not going back to Kansas. I was going to be staying in Texas. And frankly, there's a much better legal market in Dallas than there is in Austin.
Yeah.
So I ended up at SMU Law School and moved to Dallas for law school in 1994, graduated from SMU in 97, worked for the Texas State Court of Appeals in Fort Worth for a year as a briefing attorney after law school.
Okay.
And I've been a Texas appellate lawyer ever since. So, since 1998 when I left the Court of Appeals, that's when I started practicing appellate
So
law.
did you know that was the route you wanted to take? Is
Quite
that
the
what you-
opposite. I actively didn't want to take this route.
Okay.
I thought I was going to be a trial lawyer.
Okay.
Okay. Right.
And the world had other plans for me.
Okay.
Because I was pretty confident I wanted to be a trial lawyer, I was thinking, okay, what's the best route to being a courtroom lawyer, being in trial all the time?
Right.
How do I get my trial experience? I had heard that going to work at the DA's office was a great way to do that. Get a lot of trial experience really early on misdemeanor criminal cases.
Right.
And that's how some of the very best civil trial lawyers got started. Is spending a year, 2 years, 3 years at the DA's office, getting dozens and dozens, if not hundreds, of trials. So I interned at the DA's office in Tarrant County. Really enjoyed it. I mean, it was everything I hoped it was going to be. I liked the work. I liked my colleagues. I find criminal law interesting, frankly. At the end of my 6-week internship at the Tarrant County DA's office, I was hoping to interview for a permanent job at their office. And not only did they not give me a job, they didn't even give me an interview for a job.
Really?
And they've been telling me how great I was doing the whole time. So I was thinking,
What's up with that?
were they just sandbagging me? I mean,
Right.
again and again, they were giving me great feedback on my work, and then I can't even get a 30-minute interview. So
my God.
I had a good enough relationship with my supervisors there at Shasta. I'm like, I'm not going to try to change your mind here. Whatever decision you need to make is what you need to make. But can you give me some guidance? What is it that I can be doing differently in my next internship?
Right.
Did I do something wrong and just have no idea of it? They're like, no, that's not it. You really were a hard worker. You were pleasant around the office. You did good work. You're a good researcher,
what
good
was
writer.
it?
Everyone likes you personally. You're fun
Right.
to grab lunch with. I mean, they had nothing but great things to say about me. I'm like, okay. I
Right.
didn't
I'm
get an
waiting for
interview
it.
because. And he just said, you're not a trial lawyer. You're never going to be a trial lawyer.
Really?
Oh, wow.
You're a book lawyer.
Okay.
Okay.
You do a great job in the back office, doing the research and writing, preparing our bench briefs for the trial court judges.
Right.
You write persuasively. You spot issues well. I mean, everything we told you was great, but you're not ever going to be a good trial lawyer. And he was frank, and which I asked him to be.
And that was
but
appreciated.
It was devastating nonetheless because that's
Right.
what I was certain I wanted to do. So I said, wow, okay, what do we do now? Supervisor, I appreciate you being so frank with me. What do I do with this
Right.
information now? And he said, tell you what, I am so confident that you would be a good appellate lawyer. I'm going to call a friend of mine who's a justice in the Court of Appeals in Fort Worth and see if maybe she'll bring you in for an interview. And on his recommendation, she did bring me in for an interview, and she hired me.
Wow.
So obviously, had really good things to say about me. It wasn't just blowing
Of
blowing
course.
smoke.
Right.
I spent a year working at the Court of Appeals, and I enjoyed it. I enjoyed seeing how sausage is made. how the justices conference in chambers to decide what to do with a case, what they like and don't like in appellate briefs, what they like and don't like in appellate oral arguments, which are appellate hearings. It was a fantastic experience. I still was thinking I wanted to be a trial court lawyer, though.
Okay,
I mean,
right.
it's like, well, maybe with this experience, maybe with this line in my resume, maybe with a good letter of recommendation for the judge for whom I work, maybe I'll be able to get on with the DA's office now. Or maybe a private practice firm, civil, criminal, anything.
Right.
I want to be in a courtroom. No look. Still.
Wow.
Even with a good recommendation from a judge. So, on the other hand, I was able to get a bunch of fantastic opportunities to do civil appeals. Okay. And so it became very clear that if I wanted to be employed as a lawyer, and I did, that I would be starting my career as an appellate lawyer. And I wasn't certain that I was going to stick with appellate law, but hey, listen, if I could get my foot in the door as an appellate lawyer, well, maybe the firm would let me in the courtroom every once in a while. Maybe it's like, a fourth or fifth or sixth year, whatever it is. I can slowly work my way up. This is not the path I'd chosen, but I could still make this work. Nope, I couldn't. It turned out that people thought I was really good with the appeals and pretty much confirmed what my supervisor at the DA's office had told me during my internship, that probably not cut out to be a trial lawyer. So after a few years of still thinking, well, maybe I'll pivot to becoming a trial lawyer one day, I just threw my hands up and gave up. I'm like, okay, everyone's telling me I'm good at this appeals thing. Everyone's telling me I'm not going to be any good in front of a jury. I should accept it. This is my fate. And I've embraced it and love it now.
Ever since, right?
I didn't ever dislike it, but it wasn't my first choice. It was my fifth choice, maybe. But now I absolutely love it. And I will regularly get calls from law students, junior lawyers asking, well, how do we become an appellate lawyer? I really, really want to become an appellate lawyer. Right. Little did I know at the time that the field that I ended up in, appellate law, is one that there are a lot more people wanting to get into than there are spots available. So I ended up in a field that wasn't really desirable to me, but it was desirable to like a huge number of other people.
Yeah.
Right.
So when someone asks me, how do I get into the field? I tell them the same story. I'm like, I can't tell you how to get into this because I didn't want it and ended up here anyway. I don't know that that's going to work for you. It worked for me. Now after, I've been in the appellate law field since I went to work at the court in 97 and then immediately went into private appellate practice the following year in 1998 at a mid-sized law firm. I've been doing nothing but this since 1997. So we're talking like, I'm not good at math, but I think that's like 27, 28 years now.
Yeah. So do you find that you are handling more appeals now than you did back then?
Probably fewer, but larger ones.
There we go.
When I started my career, like my first appeal was a slip and fall at an Olive Garden. There was $20,000 in dispute. So
wow.
Obviously, there was a limited amount of time I could spend working on that appeal if there was only $20,000 in dispute.
Right.
Now I'm working on much larger appeals with a lot more money at issue, a lot more complex issues. I mean, the slip and fall at an Olive Garden might have been a one-day trial. Now I'm working on plenty of appeals that were 2, 3, 4 week-long trials. So I'm actually working on fewer appeals per year now, considerably fewer than I was back then, but they're considerably larger.
Right.
After I spent 3 years working at what I would call a mid-size Dallas law firm, I was recruited to work at a large regional law firm in their appellate section. We had 14 full-time appellate lawyers there, and that's when I cut my teeth working on much, much larger cases. 8-figure cases, 9-figure cases, and that was phenomenal experience because while I'd had many, many appeals in the several years I spent working in the mid-sized firm, they weren't big appeals.
Right.
I got the experience working on much, much bigger cases, and I realized, wow, it's financially viable for the client to pay me to really deep dive, to get into all the little nooks and crannies of a case when there's 8 figures at issue, certainly when there's 9 figures at issue. Right. When there's 5 figures at issue, there's just not. I mean, I need to look at the issues that jump out at me at first glance, but I can't deep dive into every single potential issue. I can't investigate every nook and cranny if there's only $20,000 in controversy in a case. I mean, my appellate legal fees could exceed the amount in controversy.
Right.
So I needed to learn to be very efficient and basically pick the low-hanging fruit. Look at the biggest issues, the issues most likely to be effective on appeal. On the bigger cases, I can look at all the issues and maybe rank all of them and have some discussions with the client as to how many of these do we ultimately want to raise on appeal. This is one that you might not have thought of before, but here's some real benefits to raising this one in addition to the one that you thought of. In a bigger case, when I say bigger, in a case where there's more money and controversy, there's more opportunity to look into every possible angle as opposed to forcing yourself to be the most efficient possible in, say, a smaller case.
Right.
Probably the same in trial court work. If,
Yeah.
if you have a case where there's more money and controversy, you can investigate a lot more thoroughly than if it's a case in which the client really wants to watch every dollar closely.
Well, no, and we
Correct.
do. And there's so many times where the first conversation we have with our clients is, if you're going to throw good money after bad. The amount in controversy, our attorney's fees are going to exceed the amount in controversy.
I like having that discussion with clients really early
Oh
on.
yeah,
on
we
the
do.
front end.
We do on the
Correct.
front end.
Because
Yeah.
if a client, really truly wants me to investigate every single potential issue, really look at every single thing that could possibly has any chance of success, I'm happy to do that, even in a small case.
Right.
But I let them know, they might not be happy for me to do that.
Yeah.
I want to do what's in the client's interest budget wise. And if the client says, I don't care that there's only $20,000 at issues here, I'm happy to spend even more than $20,000 knowing that we've investigated every potential appellate issue. I'm okay doing that.
Right.
But I want the client to go in eyes wide open. I don't want him or her to be surprised at me for running up legal bills that are disproportionate to the amount of controversy.
And we're
right.
surprised at how many attorneys do that. No, we lay out all of the expectations on the front end, and we tell them if it's the principle of it, and we've got some clients that say don't care.
I have some of those as well.
And you're like, okay, but just, understand again, and over we tell them throwing good money after bad.
But ultimately, that's their decision.
It
They're
is.
business
It
people and need
is.
to make those decisions. I see it as a lawyer's responsibility to educate the client
Yes.
on all the different options, but ultimately to let the client make that decision.
Yep.
I had a case that went to trial in Judge Tillery's court, a civil district court here in Dallas. It was a 3-day jury trial. Generally, with the amount in controversy, it was $24,000. With that amount in controversy, it would not have merited even one lawyer doing a 3-day jury trial.
Right.
In this case, not only did it merit having the one lead lawyer doing it, it merited to the client me sitting second chair and helping with all the appellate issues.
Goodness.
So this client had 2 partner level lawyers, one being the trial court lawyer and one being me as the appellate lawyer, go through a 3-day jury trial fighting over $24,000. We did win.
Right.
We won resoundingly. But frankly, the amount at issue probably wouldn't have justified the attorney's fees
No.
for paying 2 partner level lawyers to do a 3-day jury trial. The client got exactly what she wanted, and she was thrilled.
And she was
Yeah.
thrilled. That's it. That's good.
But because we'd explained all this to her beforehand, she was fine with it.
She spent $150,000, but that's
I don't know.
okay.
I don't know if it was
4,000.
that, but it was definitely more than
Right.
$24,000.
Yeah, of course.
But she was thrilled. She got the result she wanted.
Exactly.
And
That's all that mattered.
it was discussed beforehand. It was discussed afterwards. I'm not giving any more details because
That's it.
if I disclose who the client is, that
Nope.
probably would be a problem. But
Right.
I'm just telling you that there was a case at one point in my career where that sort of thing happened.
Yeah.
Yeah.
And it all worked out okay. Client was
Right.
very happy with the win. Now, if we'd lost the case, she probably would not have been quite so happy.
Well, good job.
That's
good
right.
job.
Okay, so when did you decide to go out on your own? When did we start the law offices? Is it the law offices of Chad Ruback?
Yes,
What do you
it
call
was
it?
actually long before I decided I was going to be a lawyer.
Oh, okay.
I grew up in a family of retail. My great-grandfather came to the United States from Ukraine in 1908
Okay.
and opened a small retail store in Kansas City. And I really liked the idea of working for oneself, not having a boss, not having someone telling me what to do. I mean, I sometimes make stupid decisions, but they're my stupid decisions.
Right, that's right.
When I say stupid decisions, business decisions. Like
Right.
I might take a case that I'm going to lose money on because it's something I really, really want to work on. If I make that decision, that's on me. I don't want a boss to tell me, you need to do this, that's going to lose you money, that sort of
Right.
thing. So
Right.
I enjoy getting to make all my decisions, except at home. I have a wife for that. No.
Yeah,
I'm
no,
just-
you
I'm
have
glad
to.
you realized that.
That's it. Right. That's
okay. Well,
That's a happy
so
marriage.
I learned long before I went to law school, long before I even knew I was considering going to law school, that I was going to be on my own in some field at some point in my life. When I was at my first law firm, the mid-sized law firm, I was planning on going straight from there out on my own. I'd even started looking at office space. Hadn't gotten so far as to sign a lease, but had come pretty close. I was then recruited by the large regional law firm, and they enticed me, not just with the pay, which was substantial,
Right.
but they enticed me with the opportunity to work on cases much larger than I ever would get a chance to work on if I hadn't.
Yeah.
If I left a law firm that had me working on pretty small cases, one of my own, people would only trust me with pretty small cases because
right.
that's where my experience was.
Right.
On the other hand, if I went to work for, say, the large regional law firm that would have me working on 8-figure cases, 9-figure cases, well, frankly, it'd be a lot easier for clients to justify hiring me when they have 8-figure and 9-figure cases
Right.
after I was out on my own. So I spent 4 years there at the large regional firm working on a lot of really big cases. And there you go.
Okay.
Eventually I realized, well, I've always wanted to be on my own. There's never going to be the perfect time to do it, but this is as good as time as any. I didn't want to wake up and be my dad's age and still be working for someone else.
Right.
And so at some point I just figured, let's try it. The gentleman I worked for was wonderful. He was very gracious. When I resigned, he told me I could always have my job back if things didn't work out for me. And while I very, very much appreciate that offer that he made to me, I was thinking, oh my gosh, I sure hope I'm not back a year from now asking if the offer was
Right.
still open.
Right.
Thankfully, it was not. He and I are still on very good terms. And it really meant a lot to me that I had that safety net.
Yeah. Mhm.
Because, well, if I fall on my face, maybe I'll burn through all my savings in a year. But, well, I have a good paying job to go back to if
Right.
things don't work out. I'm very grateful that I didn't have to take him up on that
That's peace
offer.
of mind.
It is.
Definitely
So what
peace of
year
mind.
did you step out?
August of 05.
05. Okay. All right. Okay. So you've been on your own for a while
Just
now.
over 19 years.
Yeah. Fantastic.
All
Okay.
right. So with all of the experiences you've had, what advice would you give your younger self? Knowing what
Chill.
you know now.
Chill, Chad.
And how easy would that be to do?
Boy, that
It'd be
is
easy to
great.
give the advice.
Right.
Sure,
That's
sure.
right.
I've always been a hard charger. Everything I do at 110%. I always do, rev right for the red line. I mean, everything I do is, I need to do it 110% truly. And I probably would give my younger self the advice of, you're fine at 95% effort.
Right.
You're going to do a darn good job at 95% effort and maybe save that 5% reserve for when something unexpected comes up. You don't always need to be at 110% effort.
Yep.
But
That's great advice.
as you had
I love
indicated,
that.
it's much easier giving the advice than taking
Oh, absolutely.
the advice.
And it's simple.
Absolutely.
Just chill. Chill, Chad. I like that.
Like, I can't leave the office till I'm confident I've done the best I possibly can
Right.
on this thing before I go home. Well, it's still going to be there the next morning.
That's right.
It really, truly is. And maybe if I go home and get a good night's sleep, I look at it with fresh eyes the next morning, I might even be able to work on it with a better aspect, a
Right.
better perspective
Yeah.
than if I just stay late. I'm not leaving until I get this problem solved. Maybe it's okay to go home at 8 o'clock at night. I don't
right.
need to stay till 11.
That's great. Okay. What
so
else?
how has marriage chilled you?
It's
Has
given
it?
me more perspective.
Has it?
It definitely has given me perspective. I just celebrated my 15th wedding anniversary just a couple weeks ago, and I have a lot more perspective because it's not all about the hours and billing at the office.
That's right.
It's not all about, when is my next brief due? Those are extremely important to me still.
Right.
Without a doubt, they're extremely important, but it's not everything.
Right.
Now it's kind of grounding. It's nice to know that there's something else. Otherwise, no matter how hard I work on a case, no matter how great a job I do, every once in a while I'm going to lose one. I hate losing.
Right, of course.
But it was just absolutely devastating to me before. Like, there's nothing I could have done better. I really gave it my all. This judge has got it wrong. But it was devastating to me when the appellate judge got it wrong. And sometimes appellate court judges, like trial court judges, get it wrong. Not often, but they certainly do. It's less devastating to me now. I certainly hate it still. I
Right.
hate losing, but it's less life-threatening to me.
So when that happens, though, have you done several appeals then to the Texas Supreme Court?
I have, and I've had some luck
Okay.
with those as well.
Okay.
But as you might be aware, the Texas Supreme Court, just like the U.S. Supreme Court, is a court of discretionary review, meaning the vast, vast majority of cases people seek review on, they just say no thanks. They don't say the lower court got it right or wrong. They just say no thanks, we're not going to take this one up. And a lot of people understand that when it comes to the U.S. Supreme Court. The U.S. Supreme Court, can't take every single case in which people seek review.
Right.
The vast majority, the overwhelming majority, they just say, no, thank you. They don't say, lower court got it right or wrong. They just say, no, thanks, we're not going to look at this one. Texas Supreme Court has the same issue. It's not quite as extreme percentage-wise, but it's the exact same thing. The vast, vast majority of cases, they say no thank you. In fact, statistically, they say no thank you on 90% of the cases in which people seek review.
See, that's good to know. Yep.
And it's actually a little more extreme than it sounds, because people generally don't seek review on cases. They think there's very little chance the Supreme Court would be interested.
Right.
So there's a lot of self-selection there.
Yep.
If the lawyers and their clients discuss it and decide this one's a real long shot for the Supreme Court being interested in taking it up, generally they'll decide it's not worth spending the time or money asking the Supreme Court to do so.
Yeah.
So the 90% figure, you have to factor in, well, those 90% of cases that are denied, well, a lot of those cases people decide before taking them up, this is one we think there's a good chance the Supreme Court will agree to it. So, statistically, the Supreme Court doesn't take up that many cases for review, the Supreme Court of Texas. So while trial court mistakes are often fixed by the Court of Appeals, when they're not, statistically, they're unlikely to be fixed by the Supreme Court. Supreme Court generally only takes up cases that are, quote unquote, important to the jurisprudence of the state.
Right.
Meaning cases that are not just going to impact, whether your firm's client wins or loses. Rather, the Supreme Court generally only takes up cases that are important to lots and lots of other clients, lots of other judges, lots of counties throughout the state. So if they see a case where the lower court got it wrong, but it's only going to impact that one client that one time,
Right.
generally they choose to deny review, which means not to take up the case, not to consider the case. On the other hand, if the lower court got it wrong, but it's something they believe that lower courts are going to keep getting wrong and clients are going to keep getting messed over in many other cases in many counties throughout the state, that satisfies the important to the jurisprudence of the state standard that they have,
Right.
and they're a lot more likely to take that up. So when you're seeking review in the Texas Supreme Court, you really have two things you need to focus on in your filing. Not just that the lower court got it wrong, but that also it's important to the jurisprudence of the state. This isn't just going to impact my client. This is going to impact lots of lawyers' clients in lots of courts, in lots of courtrooms, in lots of counties.
Right.
So the second prong, that important to the jurisprudence of the state prong, is every bit as important, if not more important than the first prong, meaning, the lower court just got it wrong.
Yeah.
And I'll periodically have clients say, well, Chad, but the lower court got this so wrong. Well, okay, you're halfway there. Yeah.
Yeah.
But if
But
this
the
is
more
only
important
going to impact
prong-
you,
Yeah.
and chances are it's never going to impact anyone else ever
That's right.
again, we're not going to be able to get Supreme Court review, chances are.
Right.
And that's
Okay.
valuable information.
It is very much so.
Yeah.
Absolutely.
Again, I like explaining to the clients,
Yeah,
how
of
this
course.
works, what our odds are, and if a client wants me to proceed and seeking Supreme Court review, even if I think it's highly, highly unlikely the Supreme Court will take it up, as long as the client understands, this is how it works.
Right.
Here's what the odds are. Here's what the statistics are. That sort of thing. They want to proceed. I'm happy to
will.
take their money.
Right.
On the
That's
other
right.
hand, I couldn't sleep at night if I took someone's money without explaining these things
Yeah.
first.
No, that's for sure.
I want
Okay.
them to make decisions, but educated decisions.
Right.
Absolutely.
Of course.
So our podcast is Raising the Bar podcast.
Wait, hold on. First, before you go there.
Oh, yes.
Hold that thought. Siblings? Do you have brothers and sisters?
I do. I have a sister who's an elementary school teacher in Eagle, Colorado,
Okay.
which is right by Vail, Colorado. My brother is in Frisco, Texas, and he's
okay.
a sales rep for a wine distributor.
Okay.
Oh, nice.
So got a
Interesting.
bunch of nieces and nephews whom we dote on every chance we get.
Okay. Do you ever
That's
get
fun.
back home, or nobody's really there left?
No one's there anymore.
Okay, no one's there anymore.
My
Got it.
parents followed my sister to Colorado when
Oh,
it came
okay.
time for them to retire because they wanted to be around grandkids.
Right,
And
of course.
Their choices for being around grandkids were the Vail, Colorado area
Yep.
or the Frisco, Texas area.
Oh, yeah. No, Vail, Colorado would win
I
out
know.
every time.
So-
no
You
offense.
pick. Right, that's right.
No offense.
I can understand why they made the decision they made. Let's just say that.
Okay, go ahead.
Okay, so our podcast is Raising the Bar podcast. So how do you feel you have raised the bar either professionally or personally in your life?
I really enjoy mentoring. Mentoring pre-law students, mentoring law students, mentoring junior lawyers. That's how I raise the bar frankly, I got a lot of help, advice, guidance, if you will, from lawyers when I was thinking of going to law school, when I was in law school, when I was just starting my law practice. I try to pay it forward because there's no way that I can repay the generosity of the lawyers who, 30 years ago were helping me.
Right.
But I can pay it forward to the next generation. That's something I make an effort to do every single week.
Oh, that is
That's
fantastic.
perfect. That's beautiful.
That is fantastic.
All right.
Thanks to our sponsor, the Ashmore Law Firm.
We specialize in probate, estate planning, family law, guardianship, personal injury, and civil litigation.
You can find us at ashmorelaw.com.
Or by calling us at 214-559-7202.
Again, that's ashmorelaw.com.
Or calling 214-559-7202.